think the hearing should be structured, the court will set a hearing date and a structure for the hearing. At that hearing, there will be witnesses called, evidence presented, legal arguments made about the statutes, the treaties, the case law, and the requirements of Article 10, Sub 1 of the European Convention on Human Rights and Article 81B of the UK Extradition Act are the two legal issues that the court is concerned with. And I want to just briefly read those sections. Article 10, Sub 1 of the European Convention on Human Rights says, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. That's in the European Convention on Human Rights. And then the other issue is based on Article 81B of the UK Extradition Act, and it says that extradition is barred for an individual who might be prejudiced at his trial or punished, detained, or restricted in his personal liberty by reason of his nationality. The focus on that hearing will very likely be the doctrine of separation of powers in the United States, regardless of what the prosecution says that Julian Assange can admit in terms of evidence. It is only the judicial branch, the courts, that decide on the admissibility of evidence. And I know that Steve is going to get into the details of the legal arguments, but that's the structure. So we'll have to wait until the 24th, and then the court will consider the proposals by each side, the government and Julian Assange, and set a hearing date and the contours of that hearing.
Thanks, Marjorie. Stephen.
So, I've actually looked at this already. There's A and B. In fact, I have to thank this lady for bringing up that legislation, because I knew there was some extradition laws, and I knew that those were the main basis of probably the main laws that their legal team were looking at. I hadn't got around to looking at them because there were so many other issues to do with the fundamental basis of a Magna Carta and the right to not have a delay in detention without a trial. And then I was focusing on the petition side. But from the information that this lady's provided, and I'm sorry I didn't catch her name because I've just started recording it after, I haven't even finished watching. I'm very, very nearly towards the end of watching the whole 9 hours of this. It's quite a long video. It's 9 hours long. And there's a couple of other pieces I want to save out of it. Firstly, some evidence that the Crown Prosecution Service have been deleting evidence. There's a little clip from that. And then another section out of it as well. Trying to remember what that other bit is. But anyway, so this lady here, she's just told us, she's just given me the exact section and clause of that Extradition Act 2003, and I've actually looked at it. There's A and B. So the act is, and it's A or B. It doesn't have to be both A and B. It's A or B. Now the thing is, it says that an extradition is barred, completely barred. That means it's blocked. If and only if, right? But it says that it's actually barred if these conditions are met. Now, if those conditions are actually met in law, then the law says that the extradition actually is legally barred, right? Now, you don't have to argue that if those legal effects are actually in effect, because it's not like, you know, if a police guy kicks your door down, he can use reasonable force. No one ever hardly challenges that. You know, the police decide what they want to do, and then they prosecute you. They're not under prosecution, and no one questions whether that was reasonable force or not. So they get away with their activities unchallenged, unquestioned, right? Until someone questions it, then, was it reasonable or not? You can have another argument whether what's reasonable. That extradition law, it says that extradition is bad, right? It is bad. It doesn't say that it might be bad, or it could be bad, or it should be bad, or you can debate about the barring. It says it's a mathematical equation, right? If 1 plus 2 equals 3, right? In the law it says if 3 is present, right, then the extradition is bad. That is a mathematical equation. You don't negotiate maths, right? Now the thing is, therefore, if that clause is in effect, then the extradition, it's bad, right? Now, what it says is that if the extradition is being pursued and the prosecution of conviction, it says on account. This is the words that she didn't pick out. She didn't say on account. On account of, right, being of the defendant's racial, religious, political views and opinion, right? Now, the thing is, right, it says on account. What's an account? An account is a record, files, documents. On account. Where are my accounts? In the account book. Where's my casework? In the files, in the accounts, on record, on an account of his views and opinions, right? What is the newspaper, right? The newspaper or website that he published the information on is an account, right? It's an account of some material, yes, that he got from, Chelsea, whatever, but, yeah, any account has material in it, on account on the figures of doing your books, on account on your sales ledger, on account of whatever. Yes, it's Chelsea money or not, but he published it, his views and his opinion on the material, right? And it's governmental because it's military army, right? Now, political is to do with voting, elections, opinions, politics, and making a changing of laws and the running of governments. Departmental government matters. Military, education, transport, right? It's a government departmental matter of a military on account, and his opinions of what he thinks to this material that he got from Chelsea Manning, right? On account. And further than that, his account has also become his opinions, and that material has become other people's opinions and accounts and interest in political cases. His actual legal extradition case containing that material and containing his opinions and the Chelsea material and the whole thing is now the account of everyone. Multiple petitions, accounts on change.org. There's one petition on 38 degrees. There's about 5 on the Australian government website. And Robert F. Kennedy Jr., who is already on the ballot in multiple states in America on the presidential election run, political, has made an account himself, created an account of Julian Assange's opinions and actions in a political case to the British government and American government. An account of accounts, political opinions of Assange, because it's a political case. It's not a judicial only case now. Once you raise it to the government, now this is the thing, Parliament will not publish my petition. There were no Julian Assange petitions on Parliament because they won't publish them, right? Yet Jeremy Johnson KC wanted Lord Anningfield's Southwark Crown Court case as matters for Parliament to deal with. Parliament don't deal with judicial matters apparently anymore, but according to Jeremy Johnson KC, they can, right? Yet they've been putting bills through Parliament to overturn all those post office prosecutions, right? Once a petition about Julian Assange's opinions, material and casework is published on HM Petitions, I'm given a case number. I have a case number. I've been given a case number. I've got a registered case number with details of material because I screenshotted it. It doesn't appear. Doesn't even appear as rejected. So where is it? It just says the file cannot be found. Well, if it was a rejected petition, where is the rejected file? It's not there. Where is it? Because when that matter is published on House of Commons website through Jeremy Corbyn's thick NHS glasses, when he's standing on podiums outside the Royal Courts of Justice and travelling around the world on jet planes with George Galloway, but he can't open his room in Parliament, right? Walk down the corridor, right? This is what Corbyn can't do, right? Walk down the corridor in Parliament. Knock on the door, right, of the Petitions Committee. Hello? Oh, is that Cat Smith? Oh, hello, Cat. Can you get that petition published of Julian Assange's, please? Because it's a political account. And then once it's live, we've got a live political case. Oh, political case, yes. Now that's what Parliament's all about, politics. Yes, there's hundreds of thousands of people outside wanting to free Assange. You know, it's like we put those post office bills through the other day to overturn those convictions. If you just pop that on the website there, Cat, and we can get some signatures racked up officially on our very own website. Guess what? It's plugged in through the Constitutional Reform Act, Section 5, representations to the House of Commons from the courts, Royal Courts of Justice. Oh, look, there's a little light flashing now on the computer. Beep, 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 beep. Look at that. Oh, there's a political account on file. A political account concerning opinions of Julian Assange. And people signing it. It must be, it's a petition. Is that political? Yes. Oh, steam my glasses up and give me some, baby wipes. No, we'll just, bang on the, shout and scream outside the Royal Courts of Justice. But then there's, Stella Assange and, team, entourage going in to Royal Courts of Justice, got all this paperwork out, reams and reams and reams and reams of paper, right? Yes, and there's, we'll go through all the change.org petitions, and we'll go through, yes, there's some political matters, right? When in the Courts Act 2003, why does it say that upon pursuit of a resolution from either of the Houses of Parliament, the instruments and orders are subject to an annulment, right? That's interesting. If you raise a matter politically to Parliament, the orders are subject to an annulment. That's funny. When you have got a political opinion and matter in regards on account regarding an extradition, it's bad. What coincidence! Well, that's what I've been trying to do. Get it published on Parliament website, the only petition site in the whole world that won't publish a Julian Assange petition on account it might bar the extradition process. Let's get a windscreen wipers. Jeremy Corbyn's glasses are steaming up. It's 650 metres to the Royal Courts of Justice. And we get, 100,000 people have a good old jolly old bash outside there and get on the podium. But I could walk down to Cat Smith's office, knock on the door. Hello, Cat. Can you file this case, please? Because then it's subject to an immediate annulment in law and bars any further proceedings of the case. I am Jeremy Corbyn MP, after all. Representations with the Royal Courts of Justice. Might get Andrew Bridgen on the phone. Oh, I'm writing a letter to the police chief, But, I don't think Corbyn likes walking down corridors and knocking on doors. He prefers Morris dancing instead because it gets more of his punters interested. This is it. This is the problem with Corbyn. Arguments, it's already bad, done, dusted. Bad because when Parliament file it, look, there's a resolution application in here for LON 369544. We'll have to tell the Royal Courts of Justice that they'll have to put it to an immediate annulment. Just like when someone puts an appeal in from the Magistrates' Court to the Crown Court. Oh, I've just received a letter saying someone's appealing. Well, we'll have to, suspend his, just tick the box here. Would you like your driving licence back now, sir? Oh, yes, thank you. Is my disqualification subject to an annulment? Well, yes, of course it is, pursuant on the appeal, but according to the Extradition Act, you don't even have to win the appeal in Parliament or not, as long as that it's, well, put it this way, if that isn't official accounting and acknowledgement that it qualifies it for a political matter, then I don't know what is. This is internal workings of the government. This is not, registering appeal and getting the structure of a case. This is pick up a phone in one building, ring the other building, submit the forms. When you get prosecuted at a magistrate's court, right, you send the paperwork in to the Crown Court on receipt of it, right? Receive documents. Now watch the action. Doo-doo! Magic. I haven't even gone in anywhere now yet. I sent the documents in. There we go. This is it. And this is the problem with the Petitions Committee at the moment. Multiple critical flaws in service, procedure, and process.